Nobody in that courtroom expected a father to be destroyed by his own son, Smirk, but that is exactly what happened. The boy walked in with his chin up and his hands in his pockets, and an expression so thoroughly convinced of its own immunity that the bailiff near the door actually looked twice, not because the kid was threatening, but because that particular brand of contempt, worn that casually, on a face that young, meant something. It meant someone had been teaching him. And when Judge Eleanor Marsh looked up from her bench and saw that face, 17 years old, jawline still soft, eyes already ancient with the certainty that nothing in this room could touch him, she did not react. She simply wrote something on her notepad slowly and underlined it. And in that moment, every attorney who had ever appeared before Eleanor Marsh in the Grayfield County Juvenile and Family Court would have told you the same thing. When she underlines something at the start of a hearing, the hearing is not going to end the way anyone planned. The boy's name was Caden Whitmore. His father was Philip Whitmore, founder of Whitmore Consulting Group, a wealth management firm with offices in 4 cities, a man who had appeared twice on a regional business magazine's Power 50 list and who arrived that morning in a suit that cost more than most people in that building made in a month. He sat in the gallery, not at the table. His attorney, a senior partner named Leonard Hale, who billed at $700 an hour, had advised him to sit back, stay quiet, project concerned father energy. Philip Whitmore sat with his arms folded and his legs crossed and his jaw set in the particular configuration of a man who believed this was a minor inconvenience that Leonard Hale was going to resolve before lunch. Across the aisle at the other table sat a woman named Grace Odom. She was 41, a school librarian, a single mother. She was wearing a burgundy blouse and small pearl earrings that had belonged to her mother, and she had her reading glasses pushed up into her hair because she had been reviewing documents moments before the session started. Her son, Marcus, sat beside her. He was 14 years old, small for his age, with careful eyes and a habit of going very still when he was scared. The kind of stillness that looks like calm to people who don't know him but reads, to anyone paying attention, as a child doing everything in his power to hold himself together. If you have ever watched a powerful person sit in a room and believe with complete confidence that the rules bending around them is just the natural order of things, and you have wondered whether there is anywhere, any room, any human being where that confidence finally breaks, then you need to stay right here. Subscribe to this channel, because what Judge Eleanor Marsh did in the next 2 hours is the kind of thing you will think about for a long time afterward. The case on paper was a civil harassment matter. Caden Whitmore had been formally accused by Grace Odom of a sustained campaign of targeted bullying against her son Marcus, beginning in the fall semester and escalating over 5 months into something that Grace's attorney, a calm young woman named Priya Sethi, characterized in her opening as methodical, documented, and deliberately protected. Protected. That word hung in the air briefly before Leonard Hale's smooth, practiced response swept it aside. His client, he said, was a high-achieving student with no disciplinary record, the victim of a grievance by a family that had manufactured a narrative to explain their son's social difficulties. He used the phrase social difficulties with a precision that made it land like a verdict on Marcus before a single piece of evidence had been introduced. Marcus went very still. Judge Marsh wrote something down. Caden Whitmore, at the respondent's table, looked at his phone. His attorney had told him not to have his phone out. He had it out anyway. He was reading something, and whatever he was reading made the corner of his mouth lift, and he did not particularly try to hide it. He looked up once, at Marcus across the aisle, and the look was not aggressive. It was something worse. It was dismissive, the look of someone who has never once entertained the possibility of losing something. Judge Marsh saw it. She said nothing yet. She was still in the patience phase. With Judge Eleanor Marsh, the patience phase was always real and always finite, and when it ended completely. Priya Sethi began with the documentation. It was substantial. Over 5 months, Grace Odom had kept records, a yellow legal pad filled with dates, incidents, names, and exact language. Beginning the day Marcus came home from school and told her quietly, sitting at the kitchen table with his backpack still on, that a group of boys had surrounded him at lunch and that Caden Whitmore had told him in front of 8 people that his mother was a broke librarian who was going to die broke and that Marcus didn't belong in this school. She had written it down that night. She had written everything down every night for 5 months because she was a librarian, and she understood, in a way that people who work with information understand, that the truth is only useful if it is preserved. The yellow legal pad was submitted as evidence. Judge Marsh looked at it for a long time. The incidents escalated. A ruined science project, Marcus's model of a suspension bridge, which he had spent 3 weeks building and which was found destroyed in his locker in October, the pieces arranged according to Marcus's account and a witness statement from a classmate with a deliberate neatness that made it clear the destruction was not accidental. Screenshots of group chat messages in which Caden coordinated with 3 other boys to ensure Marcus sat alone at lunch every day for 6 weeks. 6 weeks by occupying every possible seat before Marcus arrived. And a video, 37 seconds of phone footage taken without Marcus's knowledge, in which Caden and 2 other boys followed Marcus down a hallway making sounds, low, rhythmic, mocking sounds, while other students watched. In the video, Marcus walked faster and faster and did not turn around. He was looking straight ahead. He was using everything he had to look straight ahead. Priya Sethi played the video on a screen visible to the bench. The sound filled the courtroom. Those sounds and Marcus's footsteps getting faster. Grace Odom looked at her hands. Marcus was very still. He was using everything he had to be very still. That's when everything changed the first time, because sitting at the respondents' table, Caden Whitmore watched the video and he smiled. Not a full smile, a contained one, a smile that he probably believed was invisible, that existed only at the corners of his mouth and in the slight brightening of his eyes. But it was visible. It was completely visible. And a woman in the gallery behind Grace Odom made a soft, involuntary sound, and one of the court officers shifted, and Judge Marsh looked up from the screen and looked at Caden Whitmore, and she looked at him the way you look at something you have just confirmed. Leonard Hale's cross-examination of Priya Sethi's evidence was skilled and swift. The yellow legal pad was a parent's subjective account. The destroyed project could not be definitively attributed to his client. The group chat showed social coordination but not targeted harassment under the legal threshold. The video, and here he was careful, very careful, showed students being students in an admittedly unkind way, but did not constitute actionable conduct. He was smooth. He was expensive. He was good at this. Then Judge Marsh asked Caden to stand. She did this quietly, without preamble. She said, "Caden, I'd like to ask you a few questions directly." This was within her authority and practice in juvenile proceedings, and Leonard Hale could not object without looking exactly like what he was, a man trying to prevent a judge from talking to a child. So he nodded tightly, and Caden stood, and for the first time that morning something shifted slightly in his posture. Not fear. Not yet, but the faintest recalibration. He had not expected to be spoken to directly. Judge Marsh looked at him. She said, "Tell me about Marcus." Caden said Marcus was a kid at school. He said they didn't really interact much. He said he was sorry if Marcus felt excluded, but he couldn't control who people chose to eat lunch with. He had clearly prepared this. It had the cadence of a rehearsed statement, the right words, the right pauses, the right quantity of apparent regret. He looked at the judge while he said it, directly, the way someone had coached him to look at the judge. His chin was still slightly elevated. There was still something performative about the remorse. Judge Marsh said, "That's interesting." She made a note. She said, "Let me ask you about the group chat." Caden said he used a lot of group chats. The judge said, "The one called Operation Invisible, the one submitted as Exhibit 4. Something shifted in the gallery. Philip Whitmore, for the first time since the session began, uncrossed his legs. "Operation Invisible," Judge Marsh said again, very quietly, as though she were reading the name of something from a list of things she had hoped not to find. "Who named it that?" Caden said he didn't remember. She said, "The metadata shows the chat was created by the account registered to your phone number. Would you like to look at Exhibit 4? He said he remembered now it was just a joke between friends. It didn't mean anything. The name didn't mean anything. And that was when Caden Whitmore said the thing that changed the energy of the entire room. He glanced sideways, not at the judge, not at his attorney, not at Marcus, but at a point in the middle distance, the look of someone who is barely tolerating a conversation they find beneath them. And he said with a sigh that he did not try to conceal, "I mean, honestly, this whole thing is kind of a joke." The courtroom went silent. Not the polite, procedural silence between speakers, the deep, charged, pressure-drop silence that occurs when someone has just revealed something about themselves that cannot be unrevealed. Marcus's mother pressed her hand to her mouth. Marcus himself turned and looked at Caden, and then looked away, and the expression on his face in that moment, not surprise, not hurt, not anger, but recognition, the quiet recognition of someone who had been telling the truth about this person for 5 months and had just been given, in front of everyone, irrefutable proof. That expression was the most devastating thing in the room. Leonard Hale said, "Caden." Judge Marsh said calmly, "Mr. Hale." And that was all she said to him. She looked at Caden. She said, "Sit down." He sat. "We are going to take a 15-minute recess." During the recess, Priya Sethi made a phone call. She had been waiting for confirmation of one more piece of evidence, confirmation that had arrived in her email 6 minutes before the session began, but which she had held professionally, waiting for the right moment. The right moment had arrived. When the session resumed, she asked to introduce a supplemental exhibit. Leonard Hale objected on procedural grounds. Judge Marsh reviewed the submission date of the evidence request, found it technically within the allowed window by 11 hours, and overruled him with the same pleasant absolute finality with which she did most things. The supplemental exhibit was a complaint record from Briarfield Academy, the private school Caden and Marcus both attended. It was not one complaint record, it was 6. Filed over 3 years by 4 different families against Caden Whitmore, documenting a pattern, that word again, pattern, of targeted social exclusion, property interference, and coordinated peer manipulation directed at students who were either newer to the school on financial assistance or both. 6 complaints. The school had responded to each one with a formal note, a parent meeting, and no disciplinary consequence. 0. Not a single suspension, not a demerit, not a formal record. The complaints had been filed, acknowledged, and quietly shelved. Priya Sethi said, "Your Honor, I would like to note that Briarfield Academy's Board of Trustees includes, as a member, Philip Whitmore, who has sat on that board for 4 years and who has, in that capacity, been present for or informed of each of these complaint proceedings." The gallery did not gasp. It exhaled. It exhaled the way a room exhales when something they suspected but couldn't prove has just been confirmed in writing, in an official record, on a screen everyone can see. Philip Whitmore in the gallery uncrossed his legs and crossed them the other way. His jaw moved once. Leonard Hale was very still. Judge Marsh looked at the complaint records for a long time. She turned pages. She read carefully. She was not performing consideration. She was actually reading, and the room waited while she read. And the waiting had a different quality now, the quality of a room that knows it is about to hear something it will not forget. She set the documents down. She removed her reading glasses. She looked at the gallery, at Philip Whitmore specifically, and she said, "Mr. Whitmore, I'm going to ask you to come forward." Leonard Hale began to stand. Judge Marsh looked at him and said, "Mr. Hale, I am not asking Mr. Whitmore for testimony. I'm asking him to hear what I'm about to say directly." Hale sat. Philip Whitmore walked to the front of the gallery rail. He stood there, impeccably dressed, jaw set, and he looked at the judge with the expression of a man who has been powerful for a long time and has constructed, around that power, a belief system in which people like him are not spoken to the way he sensed he was about to be spoken to. He stood very straight. He folded his hands in front of him. He was trying to look cooperative. He looked instead like a man who had just stepped onto ice and could feel it moving. Judge Marsh said, "What has happened in this courtroom today is not, at its core, about a group chat or a ruined science project, though both of those things are real and both caused real harm to a real child. What this is about is a system, a private school board where a parent sits with enough influence to ensure that 6 complaints against his son produce 0 consequences. A child who has learned, has been taught, whether by word or by example, that other people's pain is a social variable he can manipulate without cost. A 14-year-old boy who spent 6 weeks eating lunch alone, who walked down a hallway to the sound of mockery, who built a bridge for 3 weeks and came back to find it broken, and who has had to sit in this room today and watch the person who did those things be told again and again in one form or another that it was a joke. She looked at Philip Whitmore. Your son did not learn this in a vacuum. The confidence that this was all a joke, the ease with which he sat in my courtroom this morning and communicated that nothing here could touch him, that confidence was built somewhere. It was built in a home, and it was reinforced in a school, and both of those environments had you in them. Philip Whitmore's composure was intact, barely. His jaw was set so tight the muscle near his ear was visible. You have served on that board for 4 years, Judge Marsh continued. During those 4 years, 6 families brought documented complaints about your son's behavior to that institution. Not one produced a consequence. I want to ask you, as a matter of public record, whether you were aware of those complaints. His attorney was on his feet instantly. Judge Marsh said, Mr. Hale, your client is not under oath and is not compelled to answer. I am asking him, in this room, in front of the family his son has spent 5 months harming, whether he was aware. She looked at Philip Whitmore. Were you aware? The courtroom was absolutely, completely, historically silent. Philip Whitmore looked at Judge Marsh. He looked at her for a long time. And then, in a voice that had lost the morning's smooth authority and had become something quieter and less certain, he said, I was aware some complaints had been filed. Someone in the gallery made a sound. It was not a gasp. It was lower than that. It was the sound of confirmation. Judge Marsh nodded once. She said, Thank you for your honesty. Please sit down. She turned back to the bench. She picked up her pen. She wrote for a moment. Then she looked at Caden, who was sitting with his hands in his lap and his chin no longer elevated, who looked for the first time that morning, not like someone performing invulnerability, but like someone 17 years old in a room that had just shown him something he wasn't prepared for. The sight of his father reduced. Judge Marsh spoke to Caden directly. Her voice, when she spoke to him, was not cold. It was, if anything, the most careful her voice had been all morning. Careful in the way you are careful with something that is still forming and could still go either way. You called this a joke today, she said. I want to tell you what it looked like from here. It looked like a boy who has never been told no in a room that mattered. It looked like someone who has watched for 17 years doors open and complaints disappear and consequences dissolve, and drawn from that the only logical conclusion available, that the rules are for other people. She paused. I'm not going to tell you that you are beyond being different. I don't believe that. You are 17. But I am going to tell you that this room is the first room in your life that will not be adjusted for your last name, and I want that to mean something to you. She looked at her papers. This court finds in favor of the petitioner, Grace Odom, in full. A formal civil harassment finding is entered against Caden Whitmore. Caden is ordered to complete 40 hours of supervised community service, with a specific requirement that 20 of those hours be served at a community youth literacy program. And I'm recommending the one at the Grayfield Public Library, where Ms. Odom works, so that perhaps in the course of those hours, he might come to understand what it looks like to build something for other people rather than take from them. He is also ordered to complete a structured empathy and conflict resolution program approved by this court, with progress reports submitted quarterly. She turned to a separate page. Regarding Briarfield Academy, this court is transmitting the full complaint record, including today's proceedings, to the State Department of Education's Private School Oversight Office, with a formal recommendation that they review the school's disciplinary practices and the composition of its Board of Trustees for conflicts of interest. That review will determine whether Mr. Whitmore's continued board membership is appropriate. She set down her pen. She looked at Grace Odom, then she looked at Marcus, who had been very still for 2 hours, who was still very still, but whose stillness had changed quality. It was not the stillness of bracing anymore. It was the stillness of something that has been holding its breath for a long time and has just cautiously begun to exhale. "Marcus," Judge Marsh said. She almost never addressed the children directly at the end. The room noticed. "You kept going to school every day for 5 months. That is not a small thing. I want you to know it was seen." Marcus nodded once. His mother put her hand on his arm. Philip Whitmore left the courtroom without speaking to anyone. In the hallway, according to 2 journalists who were present, he stood near the elevator for a moment, said something quietly to Leonard Hale, and then said nothing else. Hale had the expression of a man calculating how many billable hours had just become significantly more complicated. The State Department of Education opened its review of Briarfield Academy in January. The investigation took 4 months and produced a 31-page report that found a pattern of de facto preferential treatment in disciplinary proceedings correlating with donor and trustee status. The school was required to implement an independent disciplinary review board, remove all trustee involvement from student conduct matters, and submit to an external audit of its complaint handling procedures for the prior 5 years. Philip Whitmore resigned from the board before the report was published. His resignation letter described it as a decision made in the best interest of the institution. 3 of the 4 families who had filed previous complaints received formal acknowledgments from the school, not apologies. The lawyers had apparently drawn a line there, but acknowledgments. 2 of those families told a local reporter it was the first time the school had said anything to them since they'd filed. Caden Whitmore completed his community service, all 40 hours. A supervisor at the youth literacy program described him, in a progress report submitted to the court, as initially resistant, eventually engaged. She noted that by the 6th week he had started arriving early. She did not editorialize. She reported what she saw. Grace Odom framed the court's finding and hung it in her office at the library, not as a trophy. She was not a trophy-hanging person, but because her daughter, who was 9, had asked her once whether doing the right thing worked. Grace had not known what to say in that moment. She knew what to say now. She pointed to the frame. She said, "Sometimes, in the right room with the right person sitting in it, sometimes it does." Marcus joined the school debate team in the spring. His first competitive argument was a case for increased funding for public school libraries. He won. Judge Eleanor Marsh went back to her docket the next morning. She had 28 cases scheduled. She sat in her chair and put on her reading glasses and listened. She listened with the full, unhurried attention of someone who has never stopped believing that the person standing before her matters, that their story matters, that the yellow legal pad matters, that the 37 seconds of hallway video matters, that the 14-year-old going very still in a frightening room matters. She listens because in a world where a great many powerful people have spent a great deal of time and money ensuring that certain things don't get heard, listening is not passive. It is the most precise, most deliberate, most consequential act in the room, and sometimes, in the right room, with the right person sitting in it, it is everything. If this story stayed with you, if you have ever watched someone perform in vulnerability and known quietly that they had never once sat in a room that refused to accommodate it, leave a comment. Tell us what moment hit you the hardest. The smirk, the silence after he said, "This is a joke." The moment Judge Marsh looked at the father, the moment she looked at Marcus. This channel exists for those moments, for the yellow legal pads and the borrowed blazers and the accordion folders and the 14-year-olds who kept showing up for 5 months because they had a mother who wrote everything down and believed it mattered. Subscribe because there are more of these stories and every single one of them deserves to be told all the way to the end. Share this with someone who needs to believe today that somewhere a room exists where the rules apply to everyone, because it does, and we are going to keep finding it.